Yeah, I don't understand the sliding scale thing at all, I'll be honest, so help me out. I understand lots of different facts can lead to an objectively reasonable basis, okay? And it's almost impossible to catalog them all. But on the other end, on the severity, we said in Brigham Young what we meant, Brigham City, sorry. I am tired. That it has to be a severe risk of harm to the occupant. I'm paraphrasing, but life or limb is the classic formulation in Blackstone. That's the severity is the severity. It doesn't. There's no sliding scale. You don't get to go in with lots of evidence to deal with a hangnail.
I absolutely agree with that. There's sort of, I mean, I think what we would think of with the sliding scale, there's an outer bound on the sliding scale formed by Brigham City's use of that serious injury. But not all serious injuries are alike, and our point is that based on sort of the degree of the exigency, the severity of the injury being complained about, it may be reasonable in some instances for officers to rely on less information or less reliable information, and in other instances, it may be reasonable, it may not be reasonable to rely on so little information.
Point.
So that's
Do you have any thoughts about the common law of necessity?
Yeah, I think our point is that that's a useful guidepost here for the reasons that Your Honor articulated. The fact that private individuals were able to enter when life and limb were at stake, we think provides some helpful guidance about what the framers would have thought was reasonable here. I don't think that we think of it as a direct one-to-one analog. But I don't really think it's our burden to come up with a direct one-to-one historical analog here, given that we have the text of the amendment on our side. And it's really petitioner who's asking to graft onto the Fourth Amendment's reasonableness standard this uniform probable cause requirement that is not compelled by the text of the amendment.